My name is Cecily. I am 63 years old, and my stepson told a room full of family that I had married his father for comfort. He said it the way men say things when they believe no one is left to argue, flatly, as though it were already in the record. That was 8 days after we buried my husband. My stepdaughter had already moved my overnight bag from the upstairs bedroom to the front hall. She did it while I was making tea. I came back to find it standing against the door like a visitor who had overstayed. I said thank you. I said I was sorry for everyone's loss. Then I drove 40 minutes back to my sister's spare room in Napanee and sat on the edge of a pull-out mattress and looked at the wall for a long time. For nearly 11 months, they believed that was the end of it. Here is what none of them considered. I spent 31 years as a paralegal at Whitmore & Fenn, an estate law firm on Princess Street in Kingston, Ontario. I typed wills for a living. I filed them at the courthouse. I pulled them apart, when files fought over them. I know what voids a will in this province. I knew it the morning I drove away from that house. I just had not yet decided what to do about knowing it. I met my husband at a fundraiser for the Kingston Community Land Trust in the fall of 2011. He was 69 years old, and he had run a building supply distribution company out of Napanee that his father had started in 1962. He had retired from the day-to-day the year before and was, as he put it, learning to sit still. He was not good at it. He filled the quiet with opinions about lumber grades, municipal zoning, and the correct way to store a canoe through a Canadian winter. I found that restful. After 3 decades of conference rooms, a man who had something definite to say about dimensional timber felt straightforward. We married on a Saturday in June of 2013 at the waterfront. 14 people came, including my 2 sisters and the woman who ran the dry cleaners on Division Street and had pressed my suit the morning before. My husband had been a widower for 6 years. His first wife died of cancer in the spring of 2007. He had 2 grown children from that marriage who were polite to my face, and who, I later came to understand, had conversations I was not invited to. Before the wedding, my husband's lawyer drew up a marriage contract. In Ontario, that is what they call it, a marriage contract, not a prenuptial agreement, though it comes to the same thing. We sat in his office on a Tuesday afternoon in May, and the lawyer set a folder in front of each of us. Mine was 31 pages. I am a paralegal. I read it. Clause 8 stated that each party confirmed receipt of a full and complete disclosure of the other's financial assets and liabilities, details of which were attached as Schedule B and incorporated by reference. I turned the page. There was a signature block, 2 witness lines, and a notary stamp. I asked about Schedule B. The lawyer said it was standard language, that everything had been discussed between the parties. My husband patted the edge of the table the way he did when he wanted to move forward past a difficult moment. He had already checked the hockey scores on his phone twice since we sat down. I was 51 years old and I had waited a long time to get here. I let it go. Write that somewhere you will remember it. It is the only thing in this story I should not have let go. My husband's heart gave out on a Thursday morning in March of 2024. He was in the workshop behind the house, which had been his retirement project for 3 years, a half-restored cedar canoe he was never quite satisfied with. The neighbor found him. The paramedics said it was fast. At the funeral, his children sat in the front row with their spouses and their children. I sat in the second row beside his late wife's sister, who squeezed my hand once at the beginning of the service and looked at her lap for the rest of it. Nobody moved over. 8 days later, on a Sunday afternoon, my stepson and my stepdaughter arrived at the house together. Their spouses came. A cousin I had met twice at Christmas came and stood near the kitchen counter. My stepson did most of the talking. He said his father's estate was clear. He said the will had been in place for years. He said the house was a family asset in every way that mattered. He said he hoped I understood that. My stepdaughter stood in the doorway between the kitchen and the front room. She had moved my overnight bag to the front hall while I was making tea, before anyone said a word. She set it there, the way you set out, something that does not belong to you and never did. she said. "We're not trying to make this harder than it has to be." One of the cousins looked at the window. He never spoke. I said I understood. I gathered my winter coat, a box of books, and a framed photograph of the two of us, taken the summer we went to Newfoundland. My stepson walked me out. At the car, he said the thing about comfort, that I had followed comfort when I married his father, that the family had always known it. He said it quietly, almost gently, like a man closing a book he had finished reading. I looked at him for a moment. He was 44 years old. He had his father's eyes and 3 years of quiet resentment built up for a woman he had never really tried to know. I said, "I hope the canoe turns out the way he wanted." Then I left. I moved into a 1-bedroom apartment above a hardware store on Sydenham Street. 600 square feet, baseboard heat, a window looking onto a parking structure. My pension from 31 years at the firm came to just under $2,000 a month. I was not going to be cold. But I had spent 13 years building something in a house on a lake, and the paperwork now said I had been a guest the whole time. 13 days after the house visit, my husband's lawyer called. He had handled the family's legal affairs since before my husband's first wife died. He had known those children since they were in high school. In 13 years of my marriage, he never once addressed me by my married name. He said he was calling to save me time and money. He said the will was clear. He said the marriage contract waived my rights under the Family Law Act. He said estate administration was underway and would move efficiently if everyone remained reasonable. Then he said something I filed away carefully. He said that in Ontario, a surviving spouse had 6 months from the date of the certificate of appointment to make an election against the will under the Family Law Act. He said he would hate to see me spend money pursuing a process that would not lead anywhere. I thanked him. I asked one question. I asked when the will had been signed. There was a pause. 2 seconds, perhaps 3. The kind of pause a person makes when they are checking something in their head before they answer. He said, "It has been in place since 2008, well before the marriage." I heard what that pause held. I understood which clock he believed he was running out. I did not hire a lawyer. Not that month. Not that spring. If I hired a lawyer, every person who had stood in that house would say they had seen it coming all along. The woman who married him for comfort, now reaching for money with both hands, I told myself that walking away was the dignified choice. I said the word to myself in the bathroom mirror. It took me 8 months to understand what it actually was. It was pride dressed up in quieter clothes. In November, a former colleague called me. She had been a legal assistant at the firm for 12 years before I retired, and she still works in estate law every day. She called to check on me, the way she does every few months. Near the end of the conversation, she said, almost as an aside, "Have you looked at the certificate of appointment?" I said I hadn't. She was quiet for a moment. Then she said, "It's a public document. Everything filed at the estate's office is. You of all people know you can walk in and ask." I said I wasn't ready. She said, "Cecily, they're counting on you being too polite to look." I let that sit in me for 3 weeks. Then I put on my coat. The estate's office at the Kingston courthouse is on the 2nd floor, past the elevator and the bulletin board with the outdated notices. I had walked past that counter 100 times over 30 years, filing applications for clients, pulling copies of wills to trace an inheritance chain. The clerk on duty was a young man I did not recognize. I gave him my husband's name and the year of death and asked for the complete file. He brought it back in a green folder with a rubber band. I carried it to the oak reading table by the window, set down my reading glasses, and opened to page 1. The first document in any estate file is the application for a certificate of appointment of estate trustee. It is the form the lawyer submits to open the estate. 2 pages, numbered paragraphs, signature at the bottom. Paragraph 3 read, "The deceased died leaving a will dated March 12, 2008. I circled it in pencil. Paragraph 5 read, "The deceased married Cecily on June 15, 2013. I circled that. I put my pencil down and looked at the two circles. Let me tell you what that means, because it is the whole turning point, and it is not complicated once you see it plainly. In Ontario, Section 15 of the Succession Law Reform Act states that a will is revoked by the marriage of the testator. Not challenged, not weakened, revoked. The moment my husband said I do, on June 15, 2013, his 2008 will cease to exist in the eyes of the law, unless that will had been made in contemplation of marriage to me specifically. He signed that will in March of 2008. His first wife had died 3 months before. I was 46 years old working at a firm on Princess Street, and I had never spoken to this man in my life. We did not meet for 3.5 more years. The will, when I requested a copy from the clerk, opened with the sentence, "I am not presently married. I have 2 children." He wrote that truthfully. He was a widower with 2 children. He was not writing about me. He could not have been. I did not exist in his world yet. That will was not made in contemplation of our marriage. It was made before either of us knew the other was alive. And my husband's lawyer had filed it. He had made it the exhibit, the foundation of the entire estate, without appearing to notice that paragraphs 3 and 5 of his own application, in his own words, proved it was void before it was ever submitted. I walked out past the security desk and sat on the stone bench in front of the building, where I had eaten lunch on Tuesdays for 3 decades. Then I took out my phone and called a lawyer. She practices only estates, and she does it very well. I set the application on her desk and pointed to the 2 pencil circles. She read the paragraphs. She pulled Section 15 from her bookshelf and read it in front of me without saying anything. Then she said, "And the marriage contract." I handed her my original. She read Clause 8. She asked about Schedule B. I told her there was none in my copy. She requested the file copy from my husband's lawyer. His copy did not have one either. Section 56 of the Family Law Act. A domestic contract may be set aside where a party failed to disclose significant assets or debts before signing. No Schedule B, no disclosure, no written waiver of disclosure anywhere in the document. The contract addressed divorce in 11 separate clauses. It did not use the word death once. We filed a notice of objection to the certificate of appointment and requested a hearing before the estate's court. The hearing was scheduled for a Thursday morning in February. My stepson and my stepdaughter arrived with their lawyer and their spouses. They sat on one side of the courtroom. My lawyer and I sat on the other. I brought my folder, because I always bring a folder. My stepson found me in the corridor before we went in. He looked at the folder for a moment. He said, "You should have taken what we offered when you had the chance." I said, "I read everything you offered very carefully. That was the problem." Inside the courtroom, my husband's lawyer made his presentation smoothly. He summarized the assets: the house on the lake, the investment accounts at the credit union, the registered accounts, the business interest, gross estate approximately $1.4 million. He filed the 2008 will as Exhibit A. He filed the marriage contract as Exhibit B. He noted that the surviving spouse's election period under the Family Law Act had expired and any claim was untimely. He held up Exhibit A a half-second longer than necessary before setting it on the table. The judge asked him to read from paragraph 3 of his own application. My husband's lawyer picked up the paper. He read the date of the will, March 12, 2008. He read the date of the marriage in paragraph 5, June 15, 2013. The judge asked him to read Article 1 of Exhibit A. He lifted the will. He found the first paragraph. He read, "I am not presently married." He stopped. The room was very quiet. The overhead fluorescents hummed. My stepdaughter said something low to her husband. My husband's lawyer set the document down on the table, and he did not pick it back up. He sat down instead. The judge looked at him over the top of her reading glasses. "Counsel, are you familiar with Section 15 of the Succession Law Reform Act?" My lawyer stood and used approximately 40 seconds. "Section 15 is unambiguous, Your Honor. The will predates the marriage by 5 years and 2 months. Article 1 of the will itself confirms the testator was unmarried when he executed it. The statutory exception requires the will to have been made in contemplation of marriage to this specific person, and that cannot appear from a document signed before these two people had ever met. My husband's lawyer came back up with 4 minutes of argument. He said the marriage contract controlled. He said the election window had closed. He said the court could not allow a party to sit for nearly a year and then destabilize an estate that was nearly wrapped up. My lawyer replied in one sentence, "The marriage contract is unenforceable under Section 56 of the Family Law Act for want of the financial disclosure it expressly promises to attach." The judge ruled from the bench. The 2008 will was revoked by operation of law upon the June 2013 marriage. The estate would proceed under the intestate succession provisions of the Succession Law Reform Act. Under Section 45, where the deceased leaves children who are not children of the surviving spouse, the spouse receives the preferential share, $350,000, and 1/3 of the remaining balance. My stepson put his hand flat on the back of his chair. He breathed in once, hard, and held it. My stepdaughter turned around and looked at me for 3 full seconds. Then she said, very quietly, "He changed the RRSP beneficiary designations 2 years ago. He told me when he did it. I thought you should know that." I said, "I know. I was there when he called the institution." She held my eyes for another second. Then she turned back to face the front of the room, and she did not look at me again. I do not know entirely what she meant by telling me. It may have been the beginning of something. It may have been nothing. She has not called. I have not called her either. I have not changed my number. The total settlement came to just under $480,000. My stepson and my stepdaughter divided the rest. The house was sold and the proceeds split according to the order. I put a down payment on a 2-bedroom condominium near the waterfront. It has a balcony and a coat closet, and in the morning I can see the lake from the kitchen. My husband's lawyer was referred to the Law Society of Ontario in March. The matter is still under review. Kyle and Bree, my stepson and stepdaughter, retained a firm in Toronto and filed a civil claim against him separately. I understand that case is ongoing. My stepson's plan to expand his warehouse operation fell apart because the financing he had been counting on arrived 14 months late and considerably reduced. I am told he is working through it. I hope he does. I mean that honestly, even on the days that surprises me. The canoe is in my storage locker on the ground floor of my building. It was not listed in the 2008 will, the will that no longer exists, and my stepson did not ask for it, so I kept it. It is half finished, which is how my husband left most things he loved and planned to come back to. I enrolled in a woodworking class on Tuesday evenings at the community center. The instructor says the hull lines are actually quite sound. She says whoever started it knew what they were doing. In April, I went down to the storage locker and looked at the canoe for a long time. My husband had left a small green notebook balanced on the middle thwart, the kind he used to sketch things out, to write measurements, to think on paper. I opened it. The last few pages were notes about wood and varnish and the angle of a particular rib. On the second to last page, in his handwriting, was a short list of things to do before summer. The last item on the list said, "Talk to the lawyer. Fix the will properly this time. Don't leave it until fall." He always needed 1 more week before he was ready for a hard conversation. I know that about him. I loved him anyway, and I still do. And that is a thing that does not appear on any document filed with any court. I closed the notebook and set it on the shelf above the canoe. Then I went back upstairs and made tea. The lesson of this story is not that I was smarter than anyone. I walked into a public building and asked for a file that had been sitting on a shelf since April, available to any person who walked in off the street. No appointment required, no special credentials. 50 cents a page for copies. I asked for it because a colleague said exactly the right thing at exactly the right moment, and because I had spent 31 years learning what to look for in a document before I signed it. Silence in the face of something wrong is not the same thing as dignity. I told myself for 11 months that it was. The day I finally understood the difference was the day I stopped waiting for someone else to tell me what I was permitted to read. I read everything. I always have. That was always the job.